Good morning. My name is Rick Hodgson with Washington County Attorney's Office. I am the Data Practices Compliance Officer as well as the responsible authority for data practices and for HIPAA for most of the county. We're going to spend a little bit of time today talking about data practices as it relates to county government. This is a major liability area. This is an area that we deal with every day. Every part of the county does. This is a topic that we could easily fill an entire day on new employee orientation on this topic alone. So this really is going to be a basic overview. For the typical person in a class of this sort, some of you have a vast amount of experience with data management, some it's kind of a new area. So all my goal is really today is consciousness raising. Get everybody to understand the terms, to know when there's a data practices issue. You may not always be right, because sometimes in data practices, the only luxury we have is deciding who's going to sue us. Somebody says, if you give out a record, we're going to sue you. Somebody else says, if you don't give out a record, the very same record, we're going to sue you. So you don't have to make that decision alone. We want you to get used to the notion that it's appropriate, and we encourage you to ask questions, ask your supervisors, ask folks in the county attorney's office, and we'll come up with an answer. So that's the goal of what we're going to accomplish or hope to accomplish today. So with that in mind, I'm going to give you a little bit of background, a little bit of history of what the Data Practices Act involves and the terms and the words are. Minnesota was actually one of the first, or the first state in the United States to try and develop a comprehensive data management law. Everybody else finally caught up over the years, but ours was adopted first in the mid-1970s, 1974. Every year since 1974, every legislative session, the Data Practices Act has been amended. Now that amendment, sometimes it's drastic, and other times it's relatively small, but it's always refined and tinkered with and tweaked with, and this year's no exception. Now, what prompted this to develop the Data Practices Act? Well, where the Act came from is there were a couple of philosophy and political and driving forces that got the legislature to get together and sit down and try and adopt this law. One of them, this was in the era of the immediate post-Watergate's privacy concerns. There have been stories and all sorts of reports about enemies lists from the White House and J. Edgar Hoover and domestic spying. And so there was a concern about people's right to privacy to prevent government intrusion. It used to be what we called the Big Brother countdown. It was only 10 years to 1984, only 9, 8, 7. 1984 is long come and gone. Nobody remembers George Orwell anymore, but that was still a concern, and that to this day is a concern. In fact, the major concern in the modern era of data practices is privacy intrusion in the form of using records, government non-public information for improper purposes. And that's a big push, a big emphasis right now, legally and legislatively. There was a second concern, and that was the flip side of privacy, and that is the public's right to know. And the idea was the public should have the right to know on a consistent basis what's going on. What the legislature heard stories about is whenever, everybody after Watergate wanted to become the next Woodward and Bernstein, so they go try and gather records. Maybe they want to do a story like out where I grew up, in 3 or 4 cities in the county. They'd want to do a story on what the city clerk or the city administrator was being paid. And they'd go to one city and they'd say, be told, get out of here. How'd you like it if we came down and asked your boss how much money you were being paid? They'd go to another city and they'd be given the entire file, the guy's social security number and everything else. They'd go to a third city and get something in between. And the notion was, the public has a right to know, and that should be on a kind of a consistent basis. We're either going to protect privacy consistently by information type, or we're going to let the public know by information type. So that was a competing concern. And then a third major concern at the time was, and some of us might laugh about it now, but it was the big worry about technology. The typical computer had shrunk down to probably half the size of this room. There was all that concern about what kind of technology is floating around out there that would be invasion of people's privacy. So what can we do about that as a society? That's what the legislature went to do, and they did it in Minnesota, like I say, in 1974. Now, in 1974 also, there was federal action. And the feds have 2 laws on data management, data privacy. They have the Federal Privacy Act, which is how they protect the privacy of our personal information. And they have the Freedom of Information Act, how you get federal records, federal government information. Minnesota did that in one law. We have a statute that's designed to do both. Grant access to those kind of records that we all agree should be available to the public, and then to protect the privacy of those types of records that we think should not be. So how do we do that? And why do we do that? Well, like I say, our focus is going to be on the state level. The federal government does deal with certain issues that impact us here at the county level, primarily things like taxes, some of that information. Some of the folks in this room will be part of the county's HIPAA portion. Washington County for HIPAA, the Health Information and Privacy Protection Act, Protection and Accountability Act, excuse me, is treated as, we are a hybrid entity, as I said, which means much of us in the county are not covered by HIPAA. The rest of us are, primarily in social services, some areas of health. If you work in those areas, you're going to get a lot more additional HIPAA-related training, and we're not going to spend much time on that all day. We're going to focus on the state law instead. And specifically the state statute, Data Privacy Act, the Data Privacy Act, is Chapter 13 of our statute books. And it's important to note that this is just a general overview, as I say. Depending on your work assignment, you're going to have to deal with a lot more privacy issues, a lot more specific information to your work assignment. And it's important to know the classification and how you handle data within your work area, because the exact same piece of information can have a different status as being publicly available or privacy protected, depending on who's got it. A record might be protected from public disclosure in community services, but yet it might be public information in the sheriff's office or the probation department or in the county attorney's office. So you'll learn and develop expertise in this area to the extent you need it in your particular area of assignment. Now we have some basic principles in Minnesota. One of our first principles is one of non-secrecy. I mentioned while there's concerns about protection of personal privacy, one of the other primary premises of our law is a presumption that a record is open to the public. In other words, every government record is presumed to be available to anybody for any reason at any reasonable time. Now, of a couple hundred pages of the data practices laws, 90% probably are exceptions to that rule, but that's still the basic rule. Now, another part of that rule is the presumption is everybody gets access to a record, even if their record is about you, and we're saying that the world at large shouldn't have access to it, you should. And as part of that, we can never deny the existence of a government record. One exists. Even when we have legal authority to deny a person access to a record, we still have to admit we have it if it exists. Along those same lines, in order to facilitate people having access to records, we have to actually publish a list, and we do this on the Washington County's internet, a list by category type of all of the information, all of the data that is about a particular individual that we have classified as being something other than public. The terms that you'll hear me use in a few minutes here are private or confidential. So we have to keep a directory of private or confidential information or data on people by category type. So where do we look? There's a couple of places we look to find out what the rules are. Of course, the statutes are the first place we look. But there are three other major places, as you can see, that we look. One of those are administrative rules. These administrative rules are published by the state of Minnesota. The entity within the state of Minnesota is the Department of Administration. The Minnesota Commissioner of Administration is the state agency, the state entity, that is legally responsible for interpretation and enforcement of the Data Practices Act. And so they've issued rules that have the force and effect of law. So we look at those for some guidance as to what the rules are. A second place we look is what's known as commissioner opinions. Within the Department of Administration, they have a Data Practices Division. It's called the Information Policy Analysis Division, IPAD for short. And I suspect that they wish long ago that they had put a patent or a copyright on that name. But the IPAD division has the authority to issue advisory opinions. Now, these advisory opinions are not like court decisions in the sense they're not binding. But if we follow an advisory opinion, one that we asked for or one that's previously been issued, and later the Supreme Court of Minnesota, for example, says that that opinion is wrong, we are very much protected from liability. Very limited. There can be no claim, no successful claim that we've acted maliciously or criminally in any manner. So that's a very useful source of information that we use with some frequency. And then, of course, by now, after all these many years, after 40 years on the books, we have a lot of court decisions. We have case law, we have Supreme Court cases, Court of Appeals cases, hundreds of different legal interpretations. Now, like everything else in the court world and the legal world, not all those decisions are consistent with each other. They might conflict, just like someone's commissioner opinions might conflict with each other. But at least they give us some source of guidance that I, in giving legal advice on data practices, can turn to. So, how do we do that? How do we make the Act work? Well, Chapter 13, the Data Practices Act, applies to all government agencies in Minnesota, from the state on down. So all political subdivisions are covered by the Act. And the idea is to have, like I said, similar type of agencies treat similar data in a similar way. So police departments and sheriff's offices, for example, should treat their criminal investigations in the same way. All the personnel records, whether it's at a school district or a county or a city, should be treated in approximately the same way. That's the theory behind the Act. And then to implement that theory and be consistent, 4 basic themes, as I said. The first is all government records, all government data is presumptively public. So that's the first point. If somebody has a right to look at has public data, then they have a right to look at it free of charge. That's the second theme. The third theme, as I've already mentioned as well, similar type of information by similar organizations or entities should be kept in a similar manner. We should decide that this type of information is publicly available or is worthy of protection. So for example, I shouldn't be able to go into Ramsey County and ask for a list of everybody collecting food stamps and get it, but then go over to Hennepin County, make the same request, and be told I can't have it. Either I should have it in both, or be told in both I can't have it. That's kind of the third point there. Now the other key point is we should only collect information that we have legitimate government reason for. And as part of that as well, not only collect, but we should only access non-public information for a legitimate government reason. If we access and use information that's protected for something that's not a legitimate government reason, we can be held civilly liable, we can be held criminally liable if we act in an intentional, improper manner. And there have been thousands, there are currently a large number of lawsuits. For example, the driver's license litigation that you hear about on television and radio and read about in the newspapers. That goes to that issue that you are accessing records, collecting and accessing records for an improper reason. Now, how do we accomplish these goals? The legislature accomplished these goals by a series of definitions and then apply those definitions to certain classifications. So the definitions are found in the statute, and probably one of the most important definitions is what's covered, what's government data. And this is the definition of the statute. It means all data that's collected, created, received, maintained, or disseminated. In other words, once you have it, once you create it, once you get it from someone else, it's still your data. Now, that means it's very rare. If you get a record from a third party and somebody asks you for a copy of that record or asks to look at it, it's a very rare situation where we can legitimately deny access to that record on the grounds it came from a third party. Once we get it, it's ours. So that's a key point. Another key point in this definition is this language, regardless of its physical form, storage media, or conditions of your use. One of the very first Minnesota Supreme Court cases on data practices interpreted that language regardless of physical form. That was a case in which, to give you an idea how long ago it was back when we had a commissioner on welfare still, and we had some state hospitals that were actually still open. And there was a director of one of the state hospitals. There was an investigation alleging misconduct, inappropriate activities, mismanagement. And the media finds out about it, calls the commissioner of welfare, and argues under a First Amendment they have a right to know, and so on. The commissioner essentially responds to the effect saying, well, I can't give you a copy of this record because of this new data law, but I will let you have access to it in the sense that I'll tell you about it. So the commissioner then kind of gives them an oral debriefing as to what the allegations are. As you can imagine, that didn't make the data subject very happy, so they file a lawsuit on his behalf, his lawyers do. And the issue before it gets to the Minnesota Supreme Court is, was there any kind of disclosure of government data, inappropriate disclosure? And the attorney for the state argued, well, we didn't give out any records, therefore there wasn't any appropriate disclosure. And the Supreme Court basically says, nice try, folks, but that language, regardless of physical form, means that even if you talk about a government record, you are disseminating a government record. Now that's important for everybody in this room to remember, because that means anytime you talk about something that's in a government file, you're disseminating government information. If all you're doing is talking about public records, not a problem. But if you're talking about information that is not classified as public, sensitive information, medical information, those types of things, and you do so in a way where that information can be overheard by third parties, or you're talking to the wrong people, like going home and telling your friends and family stories about your government assistance client that's HIV positive and telling us that person's name and so on, then you're disseminating government data. In the example I just gave, doing so improperly and even illegally that can get us all in big trouble. So that physical form language is very important to remember. You talk about a government record, you're disseminating the content of the government record. So data is classified in two broad categories. It's either data on individuals or data not on individuals. Data on individuals is a specific record about a person. When you filled out your NeoGov application to become a Washington County employee and you hit the send button, you gave the government data about you. That everything that was in that file, everything in your human resources file is data about individuals, specifically you. Data not on individuals is government data, government records, but not about a specific person. Washington County generates a roadmap and publishes it and distributes it. That roadmap distributed by Washington County is an example of data not on individuals. Now, within the categories, within data on individuals, data not on individuals, data has one of three classifications. It's either public, private, or confidential if it's on an individual. It's public, non-public, protected non-public if it's data not on individuals. And I'm going to focus on data on individuals simply because of the time, and that's where our liability items are. Public data is data that is available to anyone at any reasonable time and for any reason. That's its legal definition. Private data is defined to be data that is not available to the public at large. You can't just walk in and see it, look at it. It's not about you. But it is available to the person it's about. So an example of private data is your Social Security number. Let's say you were filling out a form and you need to use your Social Security number and you forgot what it is. You could come up to Human Resources and ask for that information. They could give you the information because it's about you. If your nosy neighbor or somebody else here in the county wanted your Social Security number, unless they had a work-related need for it, like for tax administration, they would be told they can't have it because it's private information about you. So it's not accessible to the public at large. We have a third category of data called confidential data. Now, when most people talk in the real world, private and confidential are synonymous terms. They're interchangeable. That's not true in data practices. The Data Practices Act wasn't written by real world people, it was written by lawyers. And so confidential and private mean two different things when we talk data practices. Confidential data isn't even available to the person it's about. They're still entitled to know it exists, but they don't get a chance to see it. Now, most confidential data doesn't stay that way long term. Usually something happens that makes confidential data classification change to either public or private. Probably the two biggest examples of confidential data that exist in Washington County government are confidential criminal investigative files and confidential civil lawsuit files. So for example, the sheriff's office is conducting the criminal investigation. Most of that file is going to be confidential. The idea is we shouldn't let the bad guy have a copy of it so we can see what's going on. But once that criminal case is over, then its classification is going to change, and it's going to change to primarily to public information. And so that's confidential under the Data Practices Act. Now, how does a person go about getting access to either public, private, or confidential? Well, that depends on what its classification is. How you get access and who can have access is determined by the classification of the data. So that's always the first question when there's a data request. What's its classification? Once we have that answer, then we know what has to be done in order to give the record out in a legal and a proper manner. Like I said, public data is the default classification. And if somebody's asking for public data, that's basically all they have to do. We cannot require them to put their request in writing. We can ask them to do so if we think it'll help facilitate access to the records, but we can't mandate or make them do that. So it's available, like I say, to anybody for any reason at any time. And to emphasize any reasonable time, you don't have to stay open late or during business hours. To emphasize that point, the legislature several years ago passed a statute that specifically said it's a violation of the law to ask someone who they are if they're requesting public information, because it doesn't make any difference who they are. They are entitled to it. In terms of why, we are only allowed to ask somebody why they want the information if our goal or our objective is to help them facilitate access to a record. So for example, somebody comes into the sheriff's office and says, hey, there was a deputy's squad car across the street from my house last night. I want all the public information about it. We could say, could you give us a little more information? Like what was the address? We could ask for those purposes in order to get access to the record. But on the other hand, if somebody walked in and said, there was a squad car at 123 First Avenue, Stillwater last night at 10 o'clock p.m. I want all the public data, we would have no business, no good reason to ask what they wanted it for, and we shouldn't be asking that. And like I said, generally the records can be reviewed at no cost as well. Now, if someone makes a large request, the statute does give us the authority as a county, as local government, to charge them the actual cost of our staff time to go out and compile the records. But again, that would be typically something you wouldn't have to deal with. That would be a supervisor, manager, that's going to figure out, is this a large, needless requirement? It's going to take a lot of time that we'll charge a fee for. Now, private data, as I said, is available to the person it's about. They're allowed to come and see it. It is also available to certain other organizations and people and entities. You can access private data if you have a search warrant. You're a law enforcement officer doing a criminal investigation, you get a search warrant, you could get access to the record. The other option would be a court order. Now, court orders could be done to disclose a record, court orders can be done to access a record. So for example, recently I was working on a case on behalf of involving community services, in which there was a contention that there was a harmful activity that occurred at a daycare center. The police wanted to do an investigation and do some work on this case from a law enforcement standpoint. Well, the social services information is classified as private. So the question then becomes, how do we get that private information to law enforcement? And the answer was, we applied for and got a judge to give us the legal authority to share with law enforcement those records. So if you ever get to the point where in your business activities here for the county, you say, you know, it's really important for reasons of public safety or some other valid reason, if we can come up with no other alternative, no statute or other legal mechanism to disseminate a record or give out a record, come see us because a court order is a possibility. Now, in addition to that, private data can be disseminated to the extent either required or authorized by state law or federal law. So for example, if, let's say someone was working in the public health clinic down with the WIC clinic, and a child is brought into you one day for a WIC examination and checkup. You look at the child, and that child has all sorts of bruises and contusions and injuries. Based on the training, you figure it out pretty quickly is consistent with the pattern of child abuse. Now, people's medical information is private information, but the public health nurse who does that examination is going to pick up the phone and call law enforcement or social services. And why is a public health nurse going to do that? Because that public health nurse is a mandated reporter. There's a statute that says they have to report this information. So that's an example of when we talk about authorized or required by law. The sheriff's office, once a month, sends a list to the United States Social Security Administration of jail inmates and their Social Security numbers. Now, Social Security numbers are private information. and that means they can't give it out even to another government organization without legal authority. Well, the legal authority is federal law. It says, we want to know social security numbers of people who are in the jail because we might terminate their disability benefits, for example, if we find out they're in jail. So that's an example of the statutory authority. Another way, of course, the record can be given, in addition to the data subject themselves, is through written informed consent. And we'll talk in a minute what informed consent looks like. And that informed consent has some key elements. It must be in writing, must be signed, must be dated, must be specific. Most of us here in the county work with certain data sets, so we have probably some fairly standardized sets of informed consent documents that, depending on your work zone, your responsibility, you'll become familiar with. One option, for example, if you deal with health information at all, is the state has prepared a standardized informed consent form. And we would utilize that. We're either going to give out records with that informed consent, or we often will collect records based on informed consent. Now, as I said, the data subject has a right to the information as well. Now, beyond that, the private data can be used within our organization for legitimate work-related purposes only. If we access private data for a non-work-related purpose, if we disseminate it inappropriately for non-work-related purposes, if we do any of those things, we are in violation of the law. So as I mentioned and alluded to the fact that some government agencies literally wrote out $1 million worth of checks to a claimant who claimed that her driver's license information had been illegally accessed for inappropriate reasons like 600-700 times. That's an example of there wasn't a work-related reason to do that. And as of August 1st, 2014, the legislature has increased and tightened that requirement up to make it very specific that if we're going to access a record, there should be a work reason to do that. And this county has had to pay out money in terms of civil settlements when people didn't do that. This county has also significantly disciplined employees for accessing driver's license information to find their Christmas card list or check out a coworker or something like that. So that's just inappropriate use, and there will be sanctions and penalties if that happens. We want to avoid that. That's why I'm standing here. Now, as I said, confidential data is the third type of data. How does a person get it? And the answer is they don't. That data will be used only within the organization on an appropriate need-to-know basis. We'll give them access to the fact that it exists, we'll acknowledge that, but we will not grant access to confidential data, again, unless there's a work-related statutory authorized basis to do that. Now, when we talk about access to records, one of the issues that comes up is cost. And as I said, there is generally no fee to review a record. If we have to spend a lot of hours and hours and hours compiling a record, we might charge that cost. To have a copy of a record, of a piece of government data, however, it is permissible under the law to charge copying costs. Every year, as consistent and required by law, our county board sets the annual fee schedule of what it's going to charge for example, a piece of paper. And as of the time that this material is being recorded, August, well, actually September now of 2014, for 2014, our county board has set that at 10 cents a page for a basic piece of paper. And that's been our rate for several years now. So if there are specialty items like videos or audios and so on, it may be a different fee. That again, we keep on the county's intranet. So if somebody wanted a CD of a conversation or a recording, you could figure out, now that's going to be X amount of dollars based on our fee schedule that's been approved by our county board. We do not charge fees to other government agencies or other government entities to give them copies of records. And fortunately, the same is true when we collect records from another organization, another government entity so far. And hopefully that won't change. Now there's a couple other elements of data practices I want to spend a few minutes on. And one of those is what's known as rights of data subjects. And one of the primary rights of data subjects that you hear talked about a lot is what's known as the Tennyson Morning. Some people also call it data practices rights advisory. And as the screen says, this requirement, this warning, this advisory, doesn't apply to law enforcement conducting a criminal investigation, but it applies to all the rest of us if we are going to collect private or confidential data about a person from that person. So probably everybody in this room first experienced a Washington County Tennyson Morning when you went to NeoGov and you filled out a job application with us. Somewhere on that computer screen or in all that computer electronics, you were advised things like, we are collecting your home address, your home telephone number, your home email. What are we going to do with it? Whether you have to give it to us or not? What happens if you give it to us? What happens if you don't give it to us? Who else is going to see it? And that's basically what a Tennyson Morning requires. We prefer to have them in writing, but they don't have to be. So for example, a lot of field workers, child protection workers, or social services folks, or mental health pre-petition screeners, they will give a Tennyson Morning, but they basically do it orally. Otherwise, many times when we're filling out forms and documents, we have created a Tennyson Morning. Now, like I say, you don't have to give a Tennyson Morning if you're only collecting public information. You don't have to give a Tennyson Morning if you're collecting even what's going to be private information, but it's not about the person themselves. Now, the theory behind a Tennyson Morning, by the way, it goes back to this notion that the government should only collect the information that has legitimate need for it. And the idea is we're going to let the person who's giving up some privacy make that decision. So let's simply say that my mom reads in the newspaper that there's a senior citizens low-income fuel assistance program that's being administered through county government. And so she calls me up and says, hey, will you take me down to the courthouse? I want to sign up for that. Sure, Mom, do that. Take her down, and then she sits down, and they give her a stack of forms to fill out. And that's going to give up some privacy. Clearly, it's going to tell where she lives, her income, her expenses, because that's part of this program. Well, before Mom gives up some of that privacy, she's given a Tennyson Morning. And the idea is she can balance that. She can say, well, I'm going to have to pay for this low-income fuel assistance with some privacy. Is it worth it? Privacy, heat, privacy, heat. And if she wants to protect her privacy, she gets up and leaves. And if she wants to stay warm, she pays for it with the privacy and fills out the form. And that's the theory behind the Tennyson Morning. It doesn't always work, and you can imagine that didn't work. We had to change that a little bit with the jail. It probably wouldn't work too well if somebody walks in the jail and says, if you don't tell us this information, we're not going to let you in here. So we've had to tinker with that a little bit, as you can imagine. But for the most part, for voluntary encounters, that works pretty well. And that's what a Tennyson Morning does, and that's its theory. Now, there's another option that people have, another right that people have under the statute, and that's to do what's known as an accuracy completeness challenge. And the Minnesota Supreme Court this year issued a ruling on this very topic and very much expanded the scope of these potential challenges. Let's say there's a record about you, and you go in, you exercise your data practice access rights, you see this record and say, hey, wait a minute, this record's wrong. It left something out, or it's got the wrong person, this wasn't me. You can do what's known as this accuracy completeness challenge. You file a written dispute with the agency, the entity that has the record. That organization has 30 days to respond. They either say, gee, we're sorry, we've changed the record, or they say, no, we've looked at the record and we're very comfortable and confident in the accuracy of the record. We're not going to change it. If you don't like that result, you can file an appeal through that iPad group I told you about to the Minnesota Department of Administration. And you could get to the point where the agency actually has to prove the accuracy of its record. And I tell you that simply so you understand why it's so important that your records be kept as accurate as possible for this reason and for no other. There's obviously a lot of good business reasons to do it as well, but there's this liability reason. In the meantime, once that dispute starts, until it's ultimately resolved, anytime we at the government would disclose our version of the record, we're obligated to disclose the other person's version as well. Now, we don't get a lot of these challenges here in Washington County, fortunately, and many times when we do, one of the things we are able to accomplish if the other side is reasonable is we simply make a deal saying, we're going to keep your record in the file, we'll keep our record, and anytime we disclose one, we'll disclose the other. And we can often resolve these cases that way. Now, a couple other key things. Again, duties of us as government employees. Absolutely one of them is to keep non-public information as secure as we reasonably can. And we can be held liable for intentional improper disclosure of a record. We can be held liable for negligent improper disclosure of a record. One school district here in the Twin Cities got tagged a a few years ago for a substantial amount of money because they had taken non-public school information, educational information, simply thrown it away, and somebody went digging around in the trash or whatever, found it, and filed a lawsuit about invasion of privacy. So to emphasize that, what the legislature has said is, anytime we dispose of a record that's classified other than public, whether it's private or confidential data on individuals, we have to dispose of it in such a manner as that it cannot be retrieved. So depending on your work assignment, you may have big old shredder bins, you may have secure lock bins where records are thrown in there and are hauled off. And I can't emphasize enough, if in doubt, if you have a piece of paper and you don't know whether it could go to general recycling or it should go in secure recycling, when in doubt, put it in secure recycling. There's no penalty for, from a liability standpoint at least, you may fill up the bin faster, but there's no liability penalty for putting that record, that piece of paper, that document into a secure bin when it doesn't have to be. And we'd much rather have you do that. Just as an added incentive, if you haven't been told this yet, many times the general recycling that it comes out of this office once a week, those are not volunteers that are hauling out your recycling. Well, they're volunteers in the sense that they can do that or they can do straight time in the county jail. Yes, we use sentencing to service crews for much of this activity. So these are people who have been criminally prosecuted. We don't need to make it any easier for those folks to have access to records of a sensitive private nature. So like I said, when in doubt, put it in the secure bin, put it to the shredder, get rid of it in some manner, make sure that even at disposal, it's kept reasonably secure. Now, getting the end users. So why do we care? And I've made several allusions to why we care along the way here. There's several remedies for a potential violation. One of those remedies, of course, is civil liability. I already talked about that person who got $1 million for having her privacy rights violated. That $1 million went to her. In addition, our law states that above and beyond any damages, the local government violates the act can also be required to pay costs and attorney's fees. And many times those attorney's fees can be as much or more than the actual civil liability. So there can be an award of actual damages, there can be an award of punitive damages. So we don't want to be spending that kind of money. For an intentional violation, there can actually even be criminal prosecution. It's a misdemeanor. Up until a couple of years ago, I used to be able to say there's hardly ever been any prosecutions under this statute, hardly any convictions. I can't say that anymore. I am personally aware of in excess of a dozen different criminal prosecutions that have either happened and resulted in convictions or are still pending. So we have a former county employee in county to the south of us. A couple of cities over to the west of us are they've had people under criminal prosecution for typically inappropriate access and use of non-public data. As I speak, there is still pending prosecution of a state official who allegedly accessed driving records, 19,000 of them over a period of several years. And he's subject to criminal prosecution. Although all those folks, by the way, that I just mentioned, are former government employees, because that's another huge sanction. You can be subject to discipline. You can be subject to discipline. It's authorized by state statute. Our county personnel regulations that I think you've already been through, Chapter 12 of our personnel regulations on standards of conduct, provided its grounds for discipline, up to and including termination from employment for violation of people's privacy rights. Now again, the big ticket item is disclosure or misuse of non-public data, but remember as well, we can be in trouble in all these areas if we fail or refuse to give out information we're supposed to give out. So I'm back to my initial comments. When you have a doubt, please, please, please ask someone. So who do you ask? Who are you going to call? Don't get into the Ghostbusters theme time. Talk to your supervisor if you have any questions. And then you can also call us or perhaps your supervisor will. You will see that number on the screen there. That's my direct line over at the county attorney's office. Even easier, better way to get a hold of me is to do an email. And send me an email at rick.hodgson, spelling out my last name, don't forget the second D, at the usual co.washington.mn.us. Because that way when I'm down in court, dinging around, whatever it is I'm doing, cooling my heels, I bring my electronic devices with me, I can often deal with your data practices questions in that manner. And then you've got a nice little electronic trail as well, so you can show that you asked, you got an answer. With that, I want to thank you all for your time and attention. Wish I could have been here with you live, but most of the time I am, but had a conflict today, so you get the videotape version instead. Welcome to Washington County, and thank you.